The Iowa Utilities Board is now in session. The date is November 5th, 2018, and it is 10 o'clock a.m. My name is Jerry Huser, and with me today are board members Nick Wagner and Dick Lozier. This is the time set for hearing in docket number SPU 2018-0007, which involves the consolidation of a number of dockets related to Interstate Power and Light Company's Advanced Metering Infrastructure, or AMI, project. Interstate Power and Light Company has filed proposed tariffs to implement terms, conditions, and a fee for customers to have a non-standard meter for both electric and natural gas customers. Numerous customers have filed complaints surrounding different issues that have been deemed related to the AMI project, and those complaints are either included in individual C dockets or as bundled complaints. Regardless of the naming convention, all of the complaints are by order of the board consolidated under SPU 2018-0007. The tariffs are identified as docket numbers TF-2018-0029 and TF-2018-0030. In addition, IPL has requested a change in its natural gas inspection procedures due in part to the projected reduction in meter readers as part of its AMI project. That request was filed in docket number RG-0150 and has also been consolidated into this hearing. This hearing is being recorded by a certified court reporter. The hearing is governed by Iowa Code Chapter 17A and 476. And Chapters 7, 9, and 20 of the Iowa Utilities Board Administrative Rules. I will first begin by taking appearances. I would request that you please identify for me the name and order of your witnesses. Who appears for IPL?
Michael Greiveldinger for Interstate Power and Light Company.
Eric Callisto, Michael Best and Friedrich on behalf of IPL. Your Honor, the list of witnesses in the order is as follows. First is Randy Bauer. Second is David Vogensen. Third is Angela Layden Van Gundy. Fourth is Dennis Kronk. Fifth is Mark Reed. Sixth is Peter Valberg. We also have an outstanding stipulation before the board on the release of Richard Sublett, who's an IPL witness. He has provided testimony in this case on the gas docket that the chair just referenced. There has been no opposition from the other parties on that testimony.
It is my intent to address that, and as we proceed to preliminary matters, I would like to take this opportunity to remind everybody that they need to speak directly into their mics. The green light needs to be on. Otherwise, our streaming and audience members will not pick up your presentation. Who appears for the Office of Consumer Advocate?
Mark Schuling, the Consumer Advocate, and Jeff Cook, an attorney in the Office of Consumer Advocate. We have 4 witnesses. The order of the witnesses are Dr. Larry Shee, Mr. Kruger, Mr. Davison, and Mr. Turner.
Thank you. Who appears for the intervener, Ms. Kathy Matera?
My name is James Turner. I'm appearing for Kathy Matera, and we have a combined witness list with Jay Marcus's representation.
Could you please identify for me which of the witnesses you will be introducing or presenting?
I will present Kathy Matera.
Thank you. Who appears for the intervener, Mr. Jonathan Littman, AIA and Associates, Inc.?
I do. My name is Jay Marcus, and the witnesses and the order in which they will appear is John Littman, Leonard Goldman, Emily Kelly, Lauren Town, except that we have a stipulation that we will take her testimony remotely at 4:30, so that may interfere with the schedule a little. Then Tim Sheckley, after town is Ms. Matera, that Mr. Turner will introduce. Tim Sheckley, Bill Bathgate, which is subject to the ruling on the supplemental testimony, and Dr. Magda Havis, and then Dr. Kenneth Walton.
Thank you. Is there anyone else present who plans to participate in this hearing that I've not mentioned? For those who may not be familiar with the Iowa Utilities Board contested case hearings and how they are conducted, I would like to briefly explain the hearing process. A contested case hearing is a formal process governed by Iowa laws and rules. It is very much like a trial held by a judge in district court, although there is no jury. Interstate Power and Light filed the proposed tariffs, and it has the burden of proving that the tariffs and its other filings satisfy the requirements of the Iowa Code and the board rules. Therefore, IPL will go first in presenting its case. Once IPL calls a witness, the consumer advocate and the interveners will have an opportunity to ask questions if they choose to do so. The board members may also have questions, and they may ask those at any time they desire. All testimony must be provided under oath, so I will swear in each witness before he or she testifies. The parties to this proceeding are Interstate Power and Light, the consumer advocate, Ms. Matera, and Mr. Lippman. Direct testimony was filed with the board in written question and answer format prior to this hearing. Therefore, each party will present their witness, allow corrections to be made to any written testimony, and present that witness for other parties to cross-examine. Cross-examination, by definition, is the questioning of a witness during a hearing by the party opposing the one who asked the person to testify in order to evaluate the truth of that person's testimony, to develop the testimony further, or to accomplish any other objective. The scope of cross-examination is generally restricted to matters covered in the written testimony. Upon completion of the witnesses for IPL, the consumer advocate will have the opportunity to present its case next, followed by the interveners in the order that they have set out. The other parties and the board members will again have the opportunity to ask questions. IPL will then have the opportunity to present any rebuttal evidence, if it has any. Prior to IPL calling its first witness, there are some procedural and preliminary matters that I wish to address with you. First is that the state of Iowa will be conducting a quarterly test of its emergency broadcasting system, which will begin around 10:30 this morning. At the point that the test begins, we will interrupt our hearing and wait for all of that to conclude. If there are any questions on our 10:30 testing, please let me know when I address you in preliminary matters. It is also my intent to have a 30-minute lunch at approximately 1:45 to 2:15. The IUB has planned for our lunch at that time and will not be leaving the building. I realize that this may be a hardship and would ask if there are any objections to this plan. Mr. Greiveldinger?
No objections.
Mr. Schuling?
No, no objections.
Mr. Turner?
No objection.
Mr. Marcus?
I didn't understand about IUB arranging for the lunch, because otherwise we would have to go out and get some lunch, which we had planned to do with somebody bringing us in sandwiches, so it wouldn't disturb, a 30-minute break.
So if in any way I've indicated that we are buying your lunch, that is incorrect.
Okay, thank you.
You are responsible for purchasing your own lunch, and my concern is that there are only a couple of places, mostly fast food, unless you have somebody assist you with that. It appears you've taken care of that, Mr. Marcus, so thank you. For your information, we also have conference rooms available if you wish or plan to have the lunch brought in during that time. At this time, I would like to introduce the staff member who will be assisting us with any of the exhibits that you will present. The Iowa Utilities Board's process is to have one of our staff members obtain the exhibits, and they will distribute those to both the board, the court reporter, and the witness and the other parties. Mr. Kuchny, would you please raise your hand? We'll be handling that, and he will be coming down to get any exhibits that you may have during testimony. The preliminary matters that I'm aware of: first, IPL filed an objection to the intervener's request to file supplemental rebuttal testimony. The objection is overruled, and the testimony will be admitted and made part of the record. The interveners also filed a motion in limine to exclude portion of Mr. Bauer's rebuttal testimony relating to the accuracy of analog meters and to limit IPL's arguments on this issue. The motion is denied, and Mr. Bauer's rebuttal testimony is admitted and made part of the record. All other written testimony and exhibits filed prior to the hearing are admitted and made part of the record without objection. The parties filed a joint motion to waive cross-examination of IPL witness Richard Sublett and excuse him from testifying. The motion is granted, and Mr. Sublett is excused from testifying today. Ms. Matera, through her attorney, Mr. Turner, previously filed a withdrawal of the testimony of David Stetzer. The withdrawal is granted. IPL's responses to OCA data requests, as set forth in the stipulations of the parties, are admitted. As a reminder, any of those responses not already filed with the board will need to be filed in EFS, the electronic filing system of the Iowa Utilities Board, no later than 3 days following this hearing, along with any other hearing exhibits. The next item that we have to address relates to the motion to quash on the subpoena. The interveners have sought 3 things in the subpoena, one of which is production of an AMI meter, the digital meter IPL will use for those customers who opt out, and a list of people who will review information from the smart meter testing program in Dubuque. Mr. Greiveldinger, have those items been provided to the interveners?
As of this time, pending the order on the motion to quash, they have not.
Are either of the meters available for production today?
They both are.
The board is directing IPL to make those items available for the hearing today. We would ask that they be, how would you advise that we set those out for the interveners?
May I have one moment?
Yes.
We have them in a box in the car. We can bring them in and set them on if there's a table that they could be set
So
on.
my recommendation is to staff that are listening, at 10:30 when our alarm's going off, would you please bring in a table for those to be set on, or some type of something. The next issue is the I believe the next issue is the review information from the smart meter testing program in Dubuque. Is that correct, Mr. Marcus?
Your Honor, there's also the list of witnesses, and then in the motion to quash, there's the issue of the live witnesses. And I filed a supplement, which perhaps was not clear, but we wanted the live testimony. I've emailed opposing counsel. We wanted the live testimony of Ms. Stibb, who is the one who is deemed the author of the new response, providing a chart on how many times the meters pulse, pursuant to the board's order in connection with the motion to compel.
Mr. Marcus, if I understand correctly, based upon your conversation, my question to you, Mr. Greiveldinger, is Mr. Bauer able to provide testimony related to the filings that have been made in the electronic filing system on the issues that Mr. Marcus wishes to ask him questions.
Mr. Bauer would be able to answer those.
So whether it's the other individual or Mr. Bauer can answer all of those questions.
Mr. Bauer would be able to answer those questions.
So that motion is denied, Mr. Marcus, to the extent that IPL is stating that Mr. Bauer can answer the questions that you are wishing to ask of him. The motion also for any additional live testimony as it relates is denied to the extent that the board can address that issue at this time.
Thank you.
The last issue is on the list of individuals from the Dubuque Smart Meter Testing Program. Is that correct? Is that a separate issue?
I'm not sure what that issue is. I'm sorry.
It's just a list of people that were part of the testing?
Yes, we'd like to get that.
So here's my question, and the question may be to you, Mr. Marcus, or Mr. Turner. The board is of the belief that this information could have been requested during discovery or prior to the hearing. Was this information requested in discovery?
A list of the witnesses wasn't, but as I think the
Sir,
board-
Mr. Marcus, is your mic on? Is the green light on?
Sorry,
Yeah, it's one of those. You'll just you'll get it.
it takes a while sometimes. The list was not requested in discovery, but that is because we served discovery August 23rd when we first got into the case. Ms. Matera was granted the right to intervene on the 20th. We served discovery to ask about the number of pulses. We then sent out 4 or 5 letters. We got various responses. Finally, there was a motion to compel, and we got the documents on the motion to compel last Friday. But we didn't appreciate at all this issue until very much after discovery had closed. That's why I wanted the list to be able to see who are these people who really know and are working every day to get the data from the database.
Is Mr. Bauer able to testify to the issues that are being raised when he testifies?
He is able to.
So to the extent, Mr. Marcus, that you, when you are cross-examining Mr. Bauer, if you are unable to obtain information as it relates to this, then we will readdress the issue. Are there any additional preliminary matters that need to come before the board?
We have an outstanding request for confidential treatment of an exhibit supplied by one of Ms. Matera's witnesses. IPL filed that request on Friday.
So I am having a difficult time hearing you, and I don't know if it's you're just...
I'll speak louder. Is that better?
Thank you. So it is the board's intent to issue an order granting confidential treatment of the information. We just haven't gotten to it yet.
Thank you, Your Honor. If I just may add one thing, there was one typographical error in the motion. We requested confidentiality for pages 76 through 140 of Attachment A to Matara's exhibit, Matara Exhibit A, and it should be pages 77 through 141. So we were off by one page. My apologies.
So noted.
May I be heard on this?
Yeah, but on this issue, Mr. Marcus?
Yes.
Yes.
Yes, we only got the application Friday, but I do object to confidential treatment to the extent that there's information in that manual about pulsing, the number of times the meters pulse. This is information that I believe the public has the right to know, especially given a website saying that the meters pulse only 6 times a day, when the manual and a lot of the testimony that is not confidential.
So, Mr. Marcus, I'm going to cut you off just for a second because this conversation has reminded me of an issue I need to bring up. I am not aware of who all has signed confidentiality or non-disclosure agreements within our hearing today. I also want all of the parties to be aware that we will go into confidential session at the end of the hearing, so whenever that happens to be, whether it's today or tomorrow, we will do confidential all at the same time. To the extent that you're using any information that may be deemed confidential or is part of a current request, I would advise you that those conversations need to occur in closed session. I do not know if the numbers you're using are confidential or not, so it's up to IPL to make that objection if that should occur. You may continue, Mr. Marcus.
I think that really concludes it. Your ruling, I think, gives them an opportunity, and if we don't get it in during the public portion, then we would get it in during the confidential portion, so that's fine, Your Honor.
Mr. Callisto?
Your Honor, the reason that the confidentiality filing was made was because IPL is under contract with Census, not surprisingly, for installation of the AMI meters. And one of the conditions of the contract is to keep this material confidential. Census considers it proprietary. To the extent that the issue that Mr. Marcus wants to raise at this hearing, one of the issues is the number of times that the meters pulse. I suspect we're going to have a full day of testimony and cross-examination on that issue, so I don't think there's anything going to be lost in the public sphere in terms of the amount of pulsing. To the extent there's anything of additional value from the confidential documents, that of course is available to all of those who signed the NDA as well as the board itself.
And I would again state that the board has not had a chance to go through the confidential order process on your request, but it is our intent to follow that at the hearing today, and we will be issuing an order following the hearing. Mr. Schuling.
Thank you, Your Honor. Excuse me. I have offered to preliminarily go through the exhibits that all of the parties have agreed to between the 3 parties, and we have the ability to go ahead and distribute those exhibits at this time, if that'll work out.
That would be excellent.
And I'm going to start with OCA's exhibits, and the board has, as a result of a stipulation, admitted OCA's exhibits, and the exhibits are 101 through 114. We're actually going to hand out Exhibit 115, but we're not considering that to be admitted at this time. Would you put this one on the witness stand? That's just going to be available for the witness. And I have handed out all the attorneys, so we're just going there on those. That's for the witness. That's on the witness stand. They should all be marked. And I do have one more. And one of our exhibits is confidential, and so I've kept it separate, and we have marked at the top confidential. It's my understanding that both Mr. Turner and Mr. Marcus are eligible to receive the confidential exhibit.
Mr. Marcus's, I don't know that we've received a signed agreement from Mr.
I did
we did.
submit one.
Yes.
Okay. We'll confirm.
So-
But that's, yes, the 2 of them.
So
can
let
get
the
it.
record show that Mr. Turner and Mr. Marcus both have been identified as having signed the confidential non-disclosure agreement.
And so, just for purposes, the information you're given is confidential only to people that have signed confidentiality agreements. Okay.
Thank you.
And the parties, with regards to IPL, have agreed to the admittance of IPL data requests, responses to Mr. Littman and Ms. Matera. They are marked as Exhibits 200 through 213, and this is stipulated to by all the parties, and Mr. Callisto has those exhibits for distribution.
Hopefully that's enough copies. The attorneys have them already.
Mr. Callisto, there were no confidential.
Correct. No, nothing confidential from IPL in that stack.
And they've already distributed to the attorneys.
The witness has, which is confidential. No, well, I'll give them to him if I need to. So we're good. Whatever you need.
And the last one we have are the exhibits for Lippman-Matera hearing exhibits. They're exhibits 1 through 35, with some of them blank. At this point in time, all the parties have agreed to a limited amount of these exhibits, but the book will contain them all. The exhibits that everybody has agreed to at this point in time are exhibits 1 through 8, exhibit 11, exhibit 23, exhibit 24, exhibit 26, and exhibit 35. And the exhibits that are available for distribution.
Yes, they are.
Right.
Could I make an addition to that? Some of the exhibits that we listed were in contemplation of possibly not being able to have the supplemental testimony admitted. Now that the supplemental testimony is admitted, there are about 10 exhibits that are going to be admitted, and I could list those for you as well.
That one.
Marcus, would you wait until we have the books, and then we can cross them out when we
Yes, ma'am.
get them? These, Mr. Schuling, did Mr. Marcus say these were additional ones, or he can reduce them?
I got lost in it. I was going to ask that question. So,
Mar-
Mr. Marcus, are these ones that we're going to strike? The ones that you're going to tell us about?
Yes, you'll strike them to say that they're already admitted, yes.
Okay. And I'm going to ask you the same question that I asked. Are there any of these confidential?
No, there's one more.
You don't.
Excuse me. There is a confidential exhibit 47, and that we will Xerox, just a single page or single document. We'll Xerox and introduce it later. But that will be admitted. It is an IPL response to our interrogatories. We have them, thanks. What you're receiving is a binder which covers exhibits 1 to 31, and then a folder that has 4 or 5 other exhibits in it. Yes, you do.
Standing at ease.
Security and risk management. This is a test of the public address system. In the event of an emergency, this public address system will provide necessary information for
We were on the Lippman-Matera hearing exhibits binder. Mr. Marcus, I would ask, just to make sure I'm on the same page, on my hearing exhibit list, I have 1 through 35. Then I have a manila folder that has exhibits 31, 32, 34, 35. If I open up the folder and look at exhibit 31, is that the exhibit that's set out in the blue binder marked 31?
No.
Okay.
I'm sorry. No, Your Honor. In the blue binder in 31 is an article, but to clear this up, exhibits in the folder 31, that is actually, 31, 32, 34, and 35, all of the ones in the folders have been stipulated to be admitted, or they have been admitted by virtue of Dr. Havas's supplemental testimony and her exhibits now having been included in the record. So the folder contains only documents that really have already been admitted.
Okay. I have it. Do any of the parties have questions in regards to that?
No questions.
Okay, all right.
And Your Honor, if I could continue, I could tell you the other exhibit numbers that are now deemed admitted by virtue of the supplemental testimony having been accepted. So those are, and this is in addition to Mr. Schuling's list, those are 19 through 22, because those are documents that were attached to the testimony on October 19, the supplemental testimony of Mr. Lippman, and documents 27 through 34, because those are documents that were attached or accompanied the supplemental testimony on October 19th of Dr. Havas.
Mr. Schuling, because I didn't get it, what were the ones that you stated earlier were agreed to being admitted?
Sure, absolutely. Exhibit 1, Exhibit 2, Exhibit 3, Exhibit 4, Exhibit 5, Exhibit 6, Exhibit 7, Exhibit 8, and then we're going to jump to Exhibit 11. Then we're going to jump to Exhibit 23 and 24. Then we're going to jump to Exhibit 26. And then we're going to jump to Exhibit 35.
Your Honor, I do have a question on 35 on behalf of IPL. I just want to make sure that what is represented is a full and complete copy of IPL response to interrogatory number 25 from Ms. Matara.
No, it's not. It isn't. What is missing are some pages from the spreadsheet. The spreadsheet was very difficult. It's in Excel. We were trying to get it into PDF. So the spreadsheet had documents other than ones that we could conveniently copy. So it took the 3 pages from the spreadsheet that were most of interest to us. But if you think the others are relevant, we certainly stipulate that you can put them in even after the hearing anytime.
Yes, Your Honor, without having an opportunity to review the full interrogatory response right now, I guess I would like the full exhibit to be put in, which is a response from IPL to Matara interrogatory 25. I don't know as we sit here whether it has value or not, but I'm hesitant to have a partial data request response entered.
So, Mr. Callisto, I'm not even sure that we have Exhibit 35 because it doesn't appear to be in the book. It might be in the Manila doc folder, but I'm going to simplify this. IPL is directed to file the entire response to interrogatory number 25 in the electronic filing system and label it as Exhibit 35. There's no issues.
And, Your Honor, I also have a question. I think it's just a question for counsel on Exhibit 34, which appears to be a piece of testimony.
Yes, it is. Well, the top part of what you're looking at in 34 was not what we intended as an exhibit if we needed it. We only intended the table. But now that the testimony and the table has been admitted as part of Dr. Havas's supplemental testimony, it's irrelevant. I mean, it's all admitted, including her testimony.
So my understanding, Mr. Marcus, is you have withdrawn those exhibits set out that you identified previously, 19 through 22 and 27 through 34, because they're in the testimony.
In the testimony or the exhibits, yes. In the testimony, including the exhibits. Yes, Your Honor.
And Mr. Clisto, the board has already ruled on that issue. Therefore, in my mind, it's a non-issue.
I agree. The more non-issues, the better. Thank you.
I have one other item. We have one witness, Dr. Larry Shee, that is not available, will be out of state tomorrow, and I've talked to the other counsel, and nobody has objection to allowing him to testify today. So if we don't get to him in the normal course, OCA would ask that he be allowed to go out of order so that he can testify today.
So, Mr. Schuling, we will then use him as we're leading up to our witness that's testifying via the webinar, and I'll put him on when I think we're getting close. He'll go off when we pull her up, and in that way we can address it. Is there any objection to that?
No, Your Honor.
Seeing everyone shaking their heads.
No objection.
No objections. We'll use Dr. Shee in that manner.
We appreciate that, Chairman Huser.
Are there any other preliminary matters from any of the parties?
Your Honor, there are two additional exhibits that IPL would like to move into evidence at this point. I understand that there will be objections from opposing counsel, and I'm happy to hand those out as I make the request.
So will you be using those exhibits with one of your witnesses?
The first one, probably not. It could potentially be used as a cross-examination witness, or exhibit, excuse me. The second document is a document, the first, to be clear, is a data request response that IPL gave to Ms. Matara. The second is material that was referenced and reviewed by our expert witness, Peter Wahlberg, and was referenced in his Appendix A as material he looked at. So I don't think either one of these is actually going to be used, I don't believe so, in live testimony today. But I believe they both warrant entry into the docket.
Go ahead. Mr. Callisto, could you remind me of what number is on this exhibit?
My apologies, I did not mark it. But that will be, if admitted, will be IPL Exhibit 214. That's the other one.
What's the date?
And this one, Mr. Callisto, is?
What's the date?
So I'll take them in order if you don't mind, Your Honor. The second one is the referenced FCC test results that were used by our expert witness, Dr. Peter Wahlberg, in his review in preparation for this case. So on the first one, Your Honor, the request to Randy Bauer, which was answered by Mr. Bauer on September 6th, 2018. As the court can see from the narrative response, the narrative supplemental response, it's a reference to certain information that's on the FCC website. Mr. Reed, in this case, on behalf of IPL, has testified that census meters that they are providing to IPL are all compliant with FCC rules and regulations. Dr. Wahlberg, our expert witness on health matters, has relied on FCC standards. So simply having this information, I think, available to the board is related to that information. So that's my argument on our response to Matera data request number 3.
So is Mr. Bauer going to be testifying about information in both of these exhibits?
He won't be testifying specifically about this, but it's certainly available for
So when you
cross-examination.
go to present him, please bring the exhibit up, then the other parties can object at that time if they so choose, but have Mr. Bauer identify Exhibit 214.
Fine, that's fine. The second one I will do through a different witness,
Who is that witness?
Dr. Wahlberg. And that'll be
The
215.
exhibit number is?
215.
I'm sorry.
Mr. Callisto, do you have anything further?
No, Your Honor.
I'm going to go back to Mr. Schuling.
I have nothing additional.
Mr. Torme, will you come here, please? Teresa, that should be off the record. Sorry about that. The information of the parties and those in attendance in the hearing room, our live streaming has gone down, and we will be rebooting the same, but I'm not going to stop while that is occurring.
720 certified letters have been received. Many, but not necessarily all of those certified letters stated they wanted to retain or have an analog meter. You see that?
I do.
Okay. And in addition,
I apologize.
Sorry?
Can you restate which exhibit
I'm
you
sorry,
are on?
yes, it's Exhibit 26, the supplemental response. Okay.
Thank you.
And you'll see also that in the second to last paragraph, she says, in addition, they were able to identify 29 instances of customers mentioning analogs, 30 more since the previous response. You see that?
I do, yes.
And if you remember Ms. Matera's supplemental testimony, she said she sent in 420 certified letters, and a copy of that certified letter is a form letter. They all demanded analogs. Do you remember that?
I do.
Okay. In the midst of this, have you ever received a single request from somebody who got a digital meter as their choice, saying, thank you so much for giving me a digital as opposed to an analog meter? Anything to that effect?
I presume I don't count because I was giddy with excitement when I got my smart meter, but other than that, I can't recall any. I think most people are indifferent about their meters.
And in all the requests that you got for a specific meter, for an analog meter, that is despite the fact that you tell people an analog is not available when they ask. That's not your non-standard meter, correct?
That's right.
They have to go out of their way to say they want an analog. Correct?
Prior to AMI deployment, the standard meter was a digital meter. That's what we installed. I don't know. I'm just going to leave it at that.
Yeah. Well, as Mr. Schuling brought out, it wasn't the standard meter if you're counting the number of meters that are out there, correct? The number of meters that are out there are analogs. The max.
So I think you're jumping to a conclusion. A standard meter, just because it becomes a standard, doesn't necessarily mean that you're going to replace. I mean, in the case of AMI, yes, we're doing that.
Yeah.
But a standard meter is a technology upgrade, and as that older technology fails, goes out of service, you replace it with whatever that new standard is.
Well, this is your standard, and I understand you are asserting that smart meters on par have more benefits than detriments. Others disagree. But this is, when you say a standard meter, all I'm saying right now is you don't mean a meter that is predominantly out there in our customers' hands, correct?
Would you repeat that, please?
I'll try. You don't mean that by a standard meter, that it's the meter that is predominantly out there in our customers' hands. That would be an analog meter, correct?
Yes.
Okay. And you don't also mean that it's the meter that you have most experience with, correct? You've had experience with analogs for years.
Yes.
Okay, and you've had experience with smart meters that you're going to install, what, a few hundred that you've been testing?
Oh, no. Oh, no.
How many have you-
We've had smart meters in our Wisconsin service territory since 2010.
Okay, well, that's a different meter, isn't it?
No.
It's
It's a census meter. It's a slightly different variation than what we're deploying in Iowa than what we had in Wisconsin, but it's the same technology. It's the same communication technology. It's generally the same metrology.
Well, it doesn't emit pulses the same way, does it? You acknowledged in recent supplement that this technology that you're installing, I forget which, also takes a daily snapshot the census Elster meter in Wisconsin doesn't do that. There are differences, correct?
There are,
Okay.
and I just said that.
Okay, would you go to Exhibit 24? It will be 24 in your tab, Mr. Bauer.
Yes, I'm there.
Okay. So this interrogatory 2 was served August 23rd, the beginning of this matter for us, the interveners. And it asks you, IPL, to state all reasons, if any, and A is why IPL will not allow customers to opt out and retain their analog meters if they have one. And your answer, and there are a few parts to the answer. Part 1, IPL has not purchased new analog meters since 2010. Okay. And in part, what that means is you don't know the market for analog meters. You haven't been out there, correct?
Define what you mean by the market.
You don't know what the buyers and sellers are doing. You don't know what all the utility companies' experience is with analogs. You don't know what the cost of an analog meter is, etc. You don't know the market.
I disagree with that.
Well, on what basis, if you haven't been buying them for 2010, do you think you know the market?
They're not offered as new meters anymore.
Okay. Any other reasons that you know the market?
Technology changed.
Any other reasons that you know the market?
No.
Okay. And your second answer here has been, it's been your practice when an analog meter fails to replace it with a digital meter. Your practice is just your unilateral determination that that's what you want to do. It's not necessarily a reason, just because it's your practice, to refuse somebody an analog meter that they desire for whatever reason, good faith, health reasons, and so forth, correct? Your practice doesn't have much to do with giving them a choice, is what I'm getting at.
Our practice also dealt with the fact that analog meters were no longer available new. We've made a practice to buy new meters, and analog meters are no longer offered as new meters. Digital meters are.
Okay.
It's an evolution in technology, sir.
Okay, let's get to that. You know that there are, I mean, Mr. Goldman has identified some approximately 18 utilities in various states that offer analog meters as an opt-out choice, correct?
I know he had a list. I'd like to see his testimony if we're going to go very deep into this.
Well, have you bothered to go through his list? And
I have.
okay, and did you call the utilities to find out what, you said you couldn't tell, for example, in some of your responses, whether it was digital or analog. Okay, so you didn't call the utility. They would know, correct?
Yes.
Okay. So your analysis of Mr. Goldman's list is at least not thorough to the extent that you didn't follow up with phone calls to determine whether your evaluation of that list was correct.
I did not.
Okay. And so you wouldn't know, for example, whether a utility company that is offering an analog option is very satisfied in terms of reliability and accuracy and so forth with the analog that they are permitting a customer to obtain, correct?
No.
Okay. And did you call any refurbishers of analogs who may be offering analogs to determine anything about the refurbished analogs that they're offering?
We have a business relationship with Vision Metering out of South Carolina. They offered refurbished analog meters.
What did they tell you about their refurbished
Well,
analogs?
they'll sell us refurbished analogs for the price of a new digital.
Okay. You don't know whether the refurbishers offer particular warranties on their analogs, do you?
I didn't ask.
Okay. And you don't know whether the refurbishers have people complaining all the time there's something wrong with these analogs, correct?
No.
And you don't know whether utilities that are getting those refurbished analogs are satisfied, correct?
I don't know that.
Okay. Okay. You also say why you won't give customers an opt-out to an analog that prior to the deployment of AMI meters, digital meters were IPL's standard meter. And that's, again, we went through the standard and what is you mean by a standard and so forth. But the last reason that you give under oath as to why you can't get an analog meter if you opt out is that it has to comply with statistical testing requirements, and it is less costly to manage those requirements for a single type of non-AMI meter in lieu of managing it for multiple. That's the essence of it, the statistical cost, in this additional response.
Can you direct me to my testimony?
Yeah, no, I'm sorry,
I'm
Mr.
sorry.
Bauer. It's the second paragraph under A.
Okay. Yes, it's less costly to have less meter test groups.
Okay. If we could go to your rebuttal exhibit A,
Okay.
that is a table, if we're at the same place.
No.
Does everybody have that? It's a table of test group sizes.
Yes.
Okay, I was just waiting to see if they want to get it up. Okay. So it's the essence of the issue, as I understand it from the interrogatory response, is you want to have one test lot rather than two in the non-standard meters, correct?
One test lot, yes.
So let's assume you have 155 meters in this statistical test lot. If you had one lot with 155 meters, you can see from the table on the right that there'd be 15 meters to test, correct?
Yes.
Okay. Now let's suppose you had two lots, though, because you had digital and analog. And you had, let's say, 35 analogs to 120 digitals. That's, maybe, somewhat the ratio that would result, something like that. If you have 35 analogs, you're going to be having 5 to test, correct?
You say the number was 35?
35, yes.
Yes.
And if you had the 120 digitals, you're going to have 10 to test, correct?
Yes.
And that number, 15, just happens to be the same as if you had one lot, correct?
Mm-hmm.
So
Yes.
in that circumstance, no difference, correct?
Yes.
Okay. Now let's suppose it's different than it's 300 to test that you would like in one lot. So if you go to 300, you have 20 to test, correct?
Yes.
And if you go and instead have 100 analogs and 200 digitals, well, you have 10 analogs to test, correct?
You lost me. Could you repeat that?
I'm sorry, 100 analogs.
100 analogs, okay.
How many to test?
You have 10.
And 200 digitals, 15 to test.
20, yeah, so it'd be
Okay.
a total of 25.
25 compared to 20. What is the extra cost to test 5 meters?
Well, it depends on where they're located. It depends. I mean, well, let's call it 50 to 100 bucks a meter.
Well, wait a second. Where they're located, I see. You test them at the residence?
No, but you have to roll a truck to go, you have to physically go roll a truck, physically remove that meter, put a different meter in, bring that meter back to the test lab, or the meter test shop,
Okay,
and test it.
okay. So it could be, according to your testimony, 5 meters times $50 or $250.
I said $50 to $100 a meter.
I know. But it could be, I said, 5 times 50 or $250, correct?
That's the low end of the range.
Okay. And there's a subsection B on that response to the interrogatory. That's Exhibit 24, back to 24, if you would. And subsection B asked, again, all reasons why customers who don't have an analog meter, why IPL will not install custom analogs for those customers. So that's a little different from A. You see, A is if they already have an analog meter, why you wouldn't allow them to keep their analog meter. B is if they don't have one, why won't you allow them to get an analog meter? But the answer is the same, correct?
Yes.
Okay. And in that answer, under oath, you don't say anything as a reason why you will not allow an opt-out to an analog, that it has to do with the inaccuracy of the analog meters, correct? Nothing said in this response.
No.
Okay. And were you the only one involved in the preparation of this response, or were there others involved?
I prepared the response.
Did you prepare it based on information you got from other people?
Certainly.
Okay. So neither you nor those other people ever guided you that you needed to say these are inaccurate analog meters. Under oath, you told us these are all the reasons, correct?
No place did I say these are all the reasons.
Well, sir, the interrogatory says state all reasons, if any. You see, this would be above A, Mr. Bauer. You know, the preamble.
I see that.
Yeah, okay. And you know, or maybe you don't know, maybe your attorneys have advised you, when you're answering interrogatories, you need to give a full and complete response. You know that, correct?
Objection. He's asking for what advice counsel has given him.
Well, apart from counsel, do you know that from any other source? That you need to give a full response. You can't be evasive. You have to respond.
I was not evasive.
I'm sorry?
I was not evasive.
Okay. And just for the record, I wasn't suggesting that you were. I was just saying we didn't get a complete response. Okay. And you didn't supplement this interrogatory response at any time in the course of this docket, did you?
No.
Okay. Could we go back to tab 26, Exhibit 26, Mr. Bauer?
Okay.
Okay. So the supplemental response, second supplemental response, excuse me, first supplemental response, it's at the top of page 2. and you see that 2,781 customers have notified IPL of their desire for non-standard meters and on the hold list, correct?
Yes, I see that.
And when you tabulate that 2781 number, you're not including analogs, people who say, I want an analog, are you?
That's all customers.
I'm sorry?
That's all customers, analog or digital.
Well, no, but the reason I'm asking, maybe I'm not being clear, is you say there 2,781 have notified IPL of their desire for a non-standard meter. Your non-standard meter is a digital meter. That's why I say you're not including the analogs in that number.
I don't understand the question, sir.
Well, what is your non-standard meter that you're offering?
A non-standard meter is a digital meter.
Okay, and this says 2,781 have told you that they want the non-standard meter, correct?
Yes.
Okay, well, that's digital, it's not an analog, correct? Maybe you don't know. If you don't know, but...
So I don't know what the breakdown is of analog versus digital in this number.
Yeah.
And I would also point out only 1,807 electric customers. There's not an analog versus digital for gas. The 2781 is gas and electric meters. The electric meters is 1807.
Okay, well, that 1807 electric, all I'm saying is then that number is the digital number, not the digital plus the analog meter. Because what you're prefacing this by, the second sentence where it breaks it down, is the customers who want your non-standard meter. And your non-standard meter is a digital meter.
The 1807 is the number of customers who do not desire a smart meter.
Okay, well, if that's the case, then you've got maybe half of those, maybe a little less than half, but something approaching half that want an analog meter, correct?
Some portion have said they desire an analog meter.
Okay, well, I was asking you for a little more specifics than that, based on the 720 certified letters, et cetera, that we talked about before. Maybe it's 40%, maybe it's 50%. Very substantial percentage of those who want a non-standard meter have told you they want an analog meter, correct?
Yes.
Okay. And that's despite you're telling them you can't even have an analog meter. It's not offered, correct?
Yes.
Okay. So you do consider a person who wants an analog meter to have opted out and requested a digital meter. Opted out and requested a non-standard meter. They are on the hold list.
Restate that if you would, please.
Sorry. Well, I want to make sure the analogs are on the hold list so that when it comes time to send them your second notice or whatever that is to the hold list, they're not going to be ignored. They're going to get a chance to get on the list, get whatever is available then, whatever the board says is available in the way of a non-standard meter. And it's not that you're going to come, sometime.
Objection, is there a question?
Yes. And that you're not going to come at some time and just substitute out their analog for a smart meter without doing the procedural things that are required for somebody on the hold list.
Everybody on this list is going to have an opportunity to either say yes or no to a non-smart meter.
Okay. Because of a notice that you give them.
Yes.
Okay. Let's go to your direct testimony, page 15, line 17.
Yes. I'm
Okay,
there.
You say, the question is, should the board order IPL to to offer an analog meter in addition to a digital meter as an NSMA choice. See that?
I do.
And you say in the first sentence, a board order requiring IPL to allow customers to select an analog meter is not consistent with IPL's board-approved tariffs that state the company will determine suitable metering equipment. Is the tariff that you're referring to here the original tariff in this case, in this docket? What tariff? It says
So we have a number of places in our tariffs that say the company will determine what suitable metering is. It's not necessarily in what we have filed as part of this proceeding, but in other places in the tariff, it does say company will determine suitable metering equipment.
Okay, let's go to Exhibit 1, which is the original tariff in this docket. First
Yes.
page of that, it's tab 1
Mhm.
in the exhibit book. First page of that, 6.07 says company will install, own, and maintain suitable metering equipment necessary for measuring electricity, etc., correct?
Yes,
That doesn't say you determine suitability. It just says that you will maintain and own suitable equipment. Correct?
well, that's what the words on paper say.
Well, they're important, aren't they? That's
They are.
your tariff.
They are.
And you're determining suitability to be a subjective test. It's up to you to decide, correct?
Yes,
And you don't believe that suitability has any aspect of objectivity in it, correct? Objectivity meaning, reasonableness.
we believe that a digital meter is a reasonable alternative.
Okay, well,
So I think we are objective.
Yeah, I'm just asking you about the definition, your interpretation of the definition of suitability, and whether suitability is an objective or a subjective test. Because when you say that you determine suitability, that's subjective. That's for you to decide. If suitability is not a subjective test, but is objective, reasonable man kind of standard, reasonable utility kind of standard, that's a different story than what your testimony is in that first sentence on page 15, correct?
Objection. That calls for a legal conclusion.
No, I'm not asking you as a lawyer. I'm asking you subjectively, you have said you determine suitability, and I'm pointing to a tariff that doesn't say you determine it. That's my point here, that suitability is really a determination of reasonableness and fairness and offering a legitimate choice and price and all kinds of things that go into making a determination reasonable.
Objection. I renew my objection, and I also ask that it appears that the counsel is testifying and not asking questions.
Mr. Marcus, I would advise you that you should make sure to be specific on the questions you're asking. If your question requires a description, maybe you could shorten that description.
Thank you, Your Honor. Okay. You understand that the price you charge for an opt-out meter has to be reasonable, correct?
Yes,
You understand that the opt-out conditions have to be reasonable, correct?
yes,
You understand that the choice of the meter should be reasonable, correct? Your choice. Yes.
yes.
And in making your choice, you should fairly evaluate the choice of the consumer, correct?
If there is a safety issue, if there is a cost issue, then I would certainly agree with that.
But otherwise, you don't think it's appropriate to consider the consumer's choices?
If we offer something that is safe and reliable, I believe we've done our diligence.
Let me give you a hypothetical, if I may. Let's suppose you're the only restaurant in town. You have a monopoly. Great deal going on. You determine what is on the menu. And if you look at cost, it would be nice to have just one dish because of the inventory, your purchasing can be streamlined, and you know that that product is safe. You have the best opportunity to evaluate safety with that one product, correct? But I assume you agree that you'll make more money, you'll have less inventory, you'll have a better opportunity to view safety with one product on the menu for all the consumers. And if they don't like it, so be it, because you got a monopoly, correct?
I think that analogy is not at all comparable to an electric meter. In the restaurant business, you could have somebody that doesn't care for beef, or somebody that doesn't care for pork, or somebody that doesn't care for chicken, or whatever it is. This is a device to measure electricity.
Okay, well,
And it's technically a viable, safe alternative.
but you understand that if you got the monopoly restaurant business, that it's in, the interest of the community. Keep people happy, to offer them, say, low-fat options, not just, the other options that would come with a single choice that you make, correct?
Yes.
Okay.
The areas that we have already deployed smart meters would have been replaced. And what was your other question?
If there were any of the non, see, I have an issue calling them digital meters because, anyway, I think I'm gonna have to resort to calling them digital meters, and I'm gonna put an asterisk next to it every time I say it. So the digital meters that are any of those been replaced with AMI?
Just hold on a
Now you
second.
Wait for.
So your question again was?
Was if any of the non-AMI digital meters have been replaced with the AMI meters?
Yeah, in all of the deployment areas where we've deployed AMI. The only exception to that would be anybody that was on the hold list did not get an AMI meter, irregardless of what type of meter it was they had.
And so they may currently have a non-AMI digital meter.
Yeah.
And earlier, there were discussions about the number of pulses per day on average or typical. And there were 6 pulses for the hourly data plus 1 daily snapshot. Can any of that daily snapshot data be transmitted at the same time as a interval pulse?
My understanding is no, that's a separate transmit.
And then at some point, there was discussion about a customer's bill being influenced by an AMI. How would a customer's bill be influenced by the type of meter that is installed at their residence?
Yeah, I think that is and that's not uncommon, that utilities, when folks get an unexpectedly high bill, and they've had an AMI meter changed out, they've come to that conclusion that the smart meter overcharges. But I think it's just didn't maybe realize it was hotter this summer than it was last summer, or there were a variety of factors that went into that.
Well, I believe this was in conversation with Mr. Marcus, and he asked something along the lines of if a customer's bill would change, and I believe your answer was you weren't sure.
You know, a place a customer's bill could change would be if they had an analog meter and that particular meter was recording slow.
Okay.
And now you bring in an AMI meter, you're within that plus or minus 2% tolerance, which maybe it wasn't before.
Okay. And do you know if any of the customers have indicated that they do not want an AMI meter if they currently have a non-AMI digital meter?
Yeah, so I think there probably are customers out there that have a digital meter now that would desire an analog meter in the future, but it would, I mean, they already had a legacy digital meter, and now they maybe want to go back to an analog.
And at one point you mentioned that the cost of replacing, I believe it was an analog with an AMI meter, and I know that number itself is confidential, but you said that is in the record, the analog to AMI, correct?
We supplied via data request, we supplied, I believe, to Mr. Marcus, the cost of an AMI meter. I don't know that we ever supplied the cost of a digital non-AMI meter.
Okay, well, you anticipated my question because it was going to be, do we have any data on or cost analysis for digital, the non-AMI digital to an AMI, and then similarly, well, yeah, that would be the only one.
We could supply confidentially the cost of a digital non-AMI meter.
Thank you.
Mr. Bauer, could you please explain to me the distinction or difference between a hub and spoke network and a mesh network?
I'll try. If I don't get it right, Mr. Reed can certainly explain it better than I can. But for the system that we are deploying, the meter communicates with the communication tower. We have about 180 communication towers spread across the state, and those meters talk directly to that tower. Now, we've had some discussion around buddy mode, but those communicate directly with the tower. A mesh network communicates, simplistically, it's like everything is in buddy mode, and the mesh network talks to the next meter, to the next meter, to the next meter, and it's a constant communication network that depends upon the other meters to pass along those pulses, if you will.
And with the buddy mode, how do you spell buddy?
B-U-D-D-Y.
It is just
like
that
my best
simple.
buddy. Yep.
Okay, so in the buddy mode,
Mm-hmm.
tell me how that differentiates from the mesh network.
Well, I mean, it would be I guess you could think of it as a little bit of a limited mesh network in terms of 1 meter to a second meter, but understand in a mesh network, it's 1 meter to another meter to another meter to another meter. Think of it as a daisy chain, whereas in the buddy mode, it's 1 meter to another meter to the communication tower.
Is it possible that in buddy mode, it could go to 1 meter, find it can't connect there, go to another meter, connect there? And then how does that differentiate between the mesh network?
I would ask that you save that question for Mr. Reed. He's the census expert on that.
Mr. Bauer, I realize I have another question along the lines of your ERT meters. Did you ever have any customers object to the ERT meter being placed on their house, or I suppose companies for that matter?
I don't recall any personally. A lot of times people like the ERT meter because you don't have to worry about leaving the door unlocked or the gate unlocked or worry about will the meter reader let the dog out or anything like that. But I don't know, I'm not aware whether we had any complaints on that or not.
Okay. And then in buddy mode, does the information from a meter's buddy get transmitted separately, or would it get transmitted at the same time that that meter was transmitting its interval data?
I'm going to defer that to Mr. Reed.
Okay, thanks.
Mr. Greiveldinger?
Thank you, Chair. Mr. Bauer, earlier today you were talking to Mr. Schuling about the privacy policy. Do you recall that line of questions? And one of the questions was, well, actually, let me back up. Do you have a copy of OCA hearing exhibit
110.
110
Yes,
in
I
front
do.
of you still? And I'm looking at the attachment there, too. And on page 3 of 4 of attachment A, there is the discussion of energy efficiency programs. Do you see that at the very top?
Is that on page 3 of 5?
3 of 4, attachment A to the response.
Oh, yeah, okay. 3 or 4, okay. Yes, energy efficiency, yes.
Are you generally aware of IPL's energy efficiency programs?
Somewhat.
Are you aware of whether IPL contracts with entities to help implement energy efficiency programs?
My understanding is we do.
Are you aware of IPL selling customer data?
I'm not.
I want to direct your attention further down the page to the section titled Analytics and Advertising Services. Do you see that?
I do.
The second paragraph in that section, could you read that, please?
Sure. These entities may use cookies, web beacons, device identifiers, and other technologies to collect information about your use of the online services and other websites and online services, including your IP address, web browser, pages viewed, time spent on pages, and links clicked. This information may be used by Alliant and others to, among other things, analyze and track data, determine the popularity of certain content, deliver advertising and content targeted to your interests on our online services and other websites and online services, and better understand your online activity.
Do you understand that provision to apply to customer load data?
I do not.
To what do you understand that provision to apply in general?
My understanding is that applies to visiting the website, if you will, and data associated with visiting websites, our website, and particular links that might be clicked on to review.
When you were talking with Mr. Schuling, he also inquired about the transition from digital to analog meters. Do you recall that?
I do.
And during that discussion, he asked you a question regarding first installing digital meters in 2010. Do you recall that?
I do.
Is 2010 the first time IPL had digital meters?
No, as I recall, we've had digital meters. When we implemented time of use program, that required a digital meter, and that was, I don't know, back in the 80s maybe it was. I don't know exactly when it was, but it was probably back in the 80s sometime.
So in 2010, when IPL last installed an analog meter, Was IPL also installing digital meters?
Yes.
When Mr. Marcus was talking with you, there was a line of questions regarding the market for analog meters. Do you recall that?
I do.
And you provided a discussion of some of your basis for understanding the analog market, correct?
Yes, I did.
You also testified that IPL sells its used analog meters, correct?
Yes, we do.
Does that provide you additional insights into the market?
Yeah. I mean, you could say it provides some insight in terms of what the value of an analog meter is.
And if you could speak in a non-confidential way, what would you say, what does that inform you about the market?
That selling used analog meters into the marketplace, you receive a pittance for the cost of those. In other words, the people that buy the used analog meters only pay a pittance.
Mr. Marcus also asked you about meter test lot sizes and posed hypotheticals of different groups and how many meters you'd need to have. Do you recall that?
I do.
And in that discussion, there was an estimate of a low-end $250 cost. Do you recall that?
I do.
And that was the meter, or the truck roll cost, correct?
Yes, it was.
Are there other costs associated with meter testing?
Sure. So you have to maintain an inventory of meters because pursuant to statistical testing, you go out, you pull the meter, you bring the meter in, you test it in the test lab. So there's an inventory that goes with that. There's also the expense that is associated with conducting the test itself, the test equipment, and the test that actually determines whether the meter passes or fails.
Mr. Marcus also had an analogy for you regarding a restaurant. Do you recall that?
I do.
And in that analogy, he indicated that the restaurant may be incented to have one meal because it could make more money. Do you recall that?
I do recall that.
Do you find any, you had indicated a fault with that analogy. Could you extrapolate on what faults you see with that analogy?
Yeah, I think Mr. Marcus's question, as you asked, was around how much profit the restaurant could make. We are as a regulated utility. That is determined by the board, so we don't have endless possibilities to make profit like what a restaurant might.
Mr. Marcus asked you also about the testing standards for the analog meters and the WRU docket. Do you recall that? And he asked you about best practice testing protocols, correct? Mm-hmm. Are the testing protocols that IPL used accepted testing protocols?
They are. We use the ANSI C 12.1 testing protocol, and pursuant to IUB rules, that is considered recommended best practice. That's contained, I believe it's in section 20.6 of the IUB rules. It's considered best practice to use that ANSI standard.
And for clarity, when you pull a meter for testing, let's say an analog meter, and that meter fails, do you put it back in service?
No, we do not. We dispose of the meter.
I want to move on to the discussion of the number of meter pings.
Okay.
And in particular, I want to reference with Marcus, tab 26 in the supplemental response.
Did you say tab 26?
Pardon me, one moment. Do you have before you the chart with the average number of meter pings in the low and the high?
I do.
Tab 3.
Thank you, Chair.
I have the table in front of me.
Can you explain why you included the minimum number of transmits in the calculus for the average?
Yeah, I think if you're going to look at an average, you need to include everything. If we would do as we suggested and take out the low number as suggested by Mr. Marcus, then I think that skews the data the other way, and you'd have to make some arbitrary decision of what should be on the high end of that. So I think to get a true average, you just include everything.
Do you believe that the numbers for the Iowa meters reflect what IPL expects long-term?
No, those average transmits will come down. I mean, if you look at Wisconsin, we are in the 6 to 7 transmits a day. That's design. In essence, that's at design, and I'd expect we'd be there in Iowa as well once we get through the tuning process.
You had testified before about a snapshot. Does WPL have a snapshot?
It does not. So any of that data, you'd have to add one additional transmit to reflect that snapshot.
The Wisconsin data shows a 1 week where a meter pinged 8,750 times.
Yes.
Given the length of a ping, how much operational time would that be?
That's about 106 seconds.
And is that per day or per week?
So that would be, in this particular instance, that would be per week.
The 106 seconds, I mean.
Yes, because the transmits were per week.
Are you sure about your math?
So you have point. So which line are you on, please?
On 8750.
Okay, so if we take 8750 times 0.085 seconds per pulse, and that 8750 is per week. So am I allowed to use a calculator on the stand?
Would we stipulate that that is per day and not per week? Is that? Are you willing to accept that?
Mr. Marcus, I need you to speak into the mic so that we can record your comment back.
Yeah. No.
Well,
Okay, he said no. I got that.
so I think it's 106 seconds a day.
And yes, you can use a calculator if you have one.
I do. That 106 is per day. I was mistaken. I
Thank you.
apologize for that.
With the Iowa numbers, there's a count of how many meters pinged more than 3,000 times, and it's generally between 2 and 4, correct?
Yes.
On a percentage basis, how many of the meters that are currently operating in Iowa would that be?
Well, it'd be, I'm going to have to get my calculator out for that. So that is 0.000943 thousandths, millionths of 1%. So it's an insignificant number.
And you stated before that when IPL sees those, that it will seek to fix them. Is that correct?
That is.
Were any of these meters triggering alarms that caused safety concerns?
They were not.
Had they been triggering safety alarms, would IPL's reaction been different?
Yes, it would have. We would have responded immediately.
The average number of pings per day in the last week in that column is 11. Do you see that?
Yes.
On a cumulative time, about how much time of ping is that?
That's about a second a day.
I have no more redirect.
Mr. Bauer, I would remind you that we will be having confidential session tomorrow, and you need to stick around for the remainder of the hearing. Colonel Wagner, did you have another? Okay. You may step down. You may call your next witness, who should be Mr. Kronk.
IPL calls Dennis Kronk.
Kronk, please raise your right arm. Do you swear that the testimony you are about to give is true and accurate?
Yes.
Seated. Mr. Callisto, you may proceed.
Please state your name and spell your last name.
Dennis G. Kronk, C-R-O-N-K.
Mr. Cook. Mr. Marcus?
Yes, Mr. Kronk, on page 3, line 11, you state your qualifications favorably as compared with real estate brokers, correct?
On line 11?
Well, you conclude about the real estate agents there, but your testimony is basically from line 3 to line 14 about the number of classroom hours that you take and the number of classroom hours that the real estate broker agent takes and so forth. Your training.
I'm making it distinguishing between the qualifications I have to value real estate and the qualifications and training that real estate agents have.
But real estate agents do things other than value real estate, correct? And they're the ones who have firsthand knowledge on the ground of what a buyer and a seller are negotiating in connection with a real estate sale, correct?
Real estate agents are primarily salespersons. They're marketers. Appraisers are valuers.
Well, I'm just asking whether or not the real estate broker or the real estate agent is the one in direct communication with a buyer and a seller as compared to you.
I communicate with buyers and sellers on a regular basis, but certainly not as frequently as a real estate agent, yes.
In fact, you come in pretty much after the fact to look at a sale that has been completed and what the selling price was, correct? You look at comparable sales prices when you're evaluating an appraisal of a piece of real estate, correct?
I do evaluate comparable sales when I estimate the value of real estate, yes.
Okay, and that's the principal thing that you do. You look at the number of square feet in a house and the different amenities and bathrooms and all of that, and compare it, those properties that have sold, and you compare it to the house that you're appraising, correct?
That's a fair statement.
Okay. But you don't know how that price was arrived at, what the negotiations were to arrive at the price, the comparable sales prices that you're looking at, correct? You don't know what the seller and the buyer discussed, what they took into account.
Well, as I said, I frequently talk to buyers and sellers and real estate agents. I interview them about negotiations, about how they came to sale prices. So I wouldn't say it's fair to say I don't have any idea.
No, but that's not the principal way that you get your information for an appraisal, correct?
No, it is. I mean, we research public records, we find comparable sales, we interview the buyers and sellers of those properties to get that information.
To get that, you just need to go to the assessor's website. Why do you interview the buyers and sellers?
Well, because frequently the appraised properties that I appraise are scrutinized, and so we like to make sure we have the whole picture. So I frequently interview buyers and sellers and verify the information from the public records.
Well, the properties that you're talking about that are scrutinized, what kind of properties are they? I'm sorry, can you answer that?
Well, it's not so much the type of property as the reason I appraise. I mean, I don't do a lot of appraisals for underwriting. Most of my appraisal work is related to legal issues, whether it be condemnation or tax appeal or estates, things of that nature.
Okay, well, what about an ordinary sale of a residential piece of real estate? Are you called to do an appraisal on that kind of a property?
Yes, at times.
Well, is that property that you're going to talk to the buyer and seller about?
Every appraiser should be making an effort to verify information with buyers and sellers. It's part of the standards.
What information would you verify? You see on the website what it sold for and what the dimensions of the house were. What would you seek to have verified?
Well, as an example, I once interviewed a seller of a property who transferred. It was a warehouse building, and part of the transfer included a pickup truck that was not part of the recorded sale price, but it was part of the transfer of interest. And so those are the kinds of things when we talk to buyers and sellers, we like to make sure, first of all, were the buyers and sellers related. Sometimes that will have an impact on sale price, and we need to know that. We need to know if there were other considerations. I like to know if I can find out how long a property was on the market. Sometimes that might indicate some distress on the part of the buyer or the seller. I like to ask many different questions to make sure I understand the full picture of what's transpired.
Have you ever asked the question of whether there were negotiations about the RF radiation in the house?
I have not.
Okay. So the particular issue that we're talking about is not something where you've talked to buyers and sellers about?
No, and I think in the vast majority of cases, buyers and sellers are not talking about that.
Okay, now I understand that. But you don't know the situation in Fairfield and with Vastu Homes and whether buyers and sellers are talking about that, correct?
I haven't appraised a home in Fairfield with regard to, with Vastu design. I've appraised an office building or two. But no, I guess I can't. I can answer that is to say no, I don't specifically know what those conversations are.
Well, if you don't know what the conversations are between a buyer and a seller of a Vastu home, why do you think you have more information, better information, on how a home with a smart meter might influence the price as compared with a broker who is talking to those people all the time.
Well, I seriously doubt that a broker is asking the specific question, how does the existence of an RF meter impact the sale price?
Well, the broker is privy to whether or not the prospective buyer is asking the broker, what's the story with the RF radiation, or is there dirty electricity here, or, should we measure with some device what the, EMF is in the home? You don't know that.
I don't.
Okay.
But I don't think they're asking whether or not that would impact the sale price.
Well, they're asking that whether it would impact this. They're asking that because it's a consideration of whether they buy the home, correct?
Well, I'm not testifying to whether or not they will buy a home. I'm testifying to the value of the home.
Well, but maybe there is a price at which they would buy the home. The real estate broker is talking to the prospective buyer or the prospective seller, or both if he's representing both, about how they feel about a smart meter in the house, correct? And okay, is that correct?
I think that's a fair statement.
Okay.
But as I stated in my testimony, I think there are many factors, many characteristics of a property, whether it be a dwelling or otherwise, that maybe aren't ultimately your preference, but doesn't mean they have an impact on sale price or value.
Right. Now, I remember that testimony. You said, for example, that, a buyer may have a checklist. He may prefer a gas stove rather than an electric stove, or something like that, correct?
That was related to renters, I believe, but yes.
Yeah, but that's the kind of thing that you're talking about that may not interfere with the sale, but is his checklist of preferences, correct?
Yes.
Do you see a difference between a buyer who is concerned about a serious health issue in his mind as compared with a gas or an electric stove? Don't you see a difference there?
I don't think the market recognizes a difference in value because of it, is what I'm saying.
Well, my question is, you see how that would be different. We're not on this. My question is limited right now to whether or not that would be more of a concern to a buyer than the electric or gas stove. If it's a health issue for him and his family, wouldn't that be something that would more make him determine potentially not to buy that house?
I can't answer that. What their concerns over health, I can't say.
No, let's suppose you had a concern over health. Wouldn't that trump in buying a house? Maybe there's mold. Maybe there is a radon issue. That's the kind of issue that you would agree is more important to a buyer than the electric or the gas stove, isn't it?
Well, I think that the issue is I can't say whether or not it's more important. I can't speak for buyers and sellers specifically, but I think that the data is not going to prove there's any difference in value. And I think that there's going to be preferences from any buyer about what they're going to buy, and they're going to make a determination what they're willing to pay based on those preferences. And I don't think there's any data to suggest that the value of a property would be any more or less because of the existence of the meters that we're talking about here.
But you understand, you've said it yourself, that the data would not likely be available. There's no data that's available on that, correct?
I don't believe there is adequate data to make that determination, and so it's my opinion that they would not have a significant impact, measurable impact.
But you're making a determination based on the absence of data and the absence of communication with the buyer and seller of a Vastu home who are interested in a home that adheres to these guidelines, correct? You don't have any information about either.
I don't have specific information. I'm just relying on my past experience with buyers and sellers.
But your past experience doesn't include ever talking to a buyer or seller of a Vastu home, correct?
That's fair.
Okay.
Mr. Marcus?
Thank you. Sorry. Um, Are you aware that in Jefferson County, for years, and I haven't done this, I'm not sure about, what the data is right now in the last couple of years, but for many years, that if you had a Vastu home, and it was being assessed, that the assessor would determine the replacement cost. That's the normal way of doing an assessment, correct? And then,
No.
well, it's a cost basis. I mean,
Well, primarily it's a sales comparison basis, but a cost basis is secondary.
yeah. Well, that's the way the statute reads, that you should determine fair market value based on comparable sales, correct?
Yes.
But it's not the way assessors do things. I mean, they may take that into account, but in general, they're looking at the number of square feet and the amenities, and they're doing a cost kind of analysis, correct?
I don't agree with that. They measure, they take a lot of data on sales, all the sales that occur in their county. They look at percentage of sales versus their assessed values, and they use that information when they're estimating assessed values.
Well, I will just tell you what, in Fairfield, for years, they've been doing it largely on a cost basis, but whatever basis they use, at the end of that analysis, they would multiply, if it was a Vastu home, at one point by 1.5. So 150% of the value they would otherwise come up with, they would attribute to a Vastu home. And if it wasn't a Vastu home, they would multiply by 0.95%. So there was a great disparity. They were, from an appraisal or assessment standpoint, giving a real premium to Vastu homes. Are you aware of that?
I was not aware of that.
Okay.
Your Honor, I'm going to object to move the strike to the last set of questions. There's nothing in the record to support what counsel has just claimed as a metric used by assessors in Jefferson County.
Mr. Marcus, do you want to attempt to,
Well, maybe I could ask the question of Mr. Lippman when he takes the stand, if you'd have no objection, and then it would be in the record.
Mr. Callisto?
Mr. Lippman is not an appraiser in Jefferson County. He's an architect, as I understand it. So I don't believe he's qualified to make that statement.
No, you don't have to be an appraiser. You just have to know the basis on which the assessor was making determinations and how they viewed Vastu homes.
My objection stands, Your Honor. This is an important piece to the extent that Mr. Marcus and his clients, he's put in two witnesses on their claim that AMI technology impacts the value of Vastu homes. We have argued, I think credibly, that neither one of them is an appraiser. One is a real estate agent and one owns a handful of residential rental properties. So there was an opportunity to put this evidence in the case through whatever professional witness he claimed. We only put our expert on because they made the claim in their direct testimony. So we only put it on in rebuttal for that purpose. To bring it in now through somebody who's not an appraiser at this stage of the game, I think is doing an end around on the board's standing procedure to get this in through pre-file testimony.
Just a moment.
And Your Honor, if I may add one other thing. The board has allowed Mr. Marcus to put an additional round of testimony in, and he chose not to put any testimony in on this issue. None of his witnesses addressed this issue in his last round of testimony.
I'm not sure. You mean
So,
that-
Mr. Marcus, just let me take care of this in a minute. Mr. Marcus, how do you know that information on the appraisal values?
I brought a lawsuit against the assessor for using 1.5 as the value rather than using a different number. We all acknowledged that there was a premium on the value of Vastu homes, and I disputed that 1.5 was the right number and that the assessor needed to come up with a different number. And it was well known, there's an opinion on it, written by the district court judge in Fairfield, Iowa. I could produce that opinion if you like.
So, Mr. Marcus, I'm going to overrule the objection, but I'm going to tell you that you need to then ask this witness the questions based upon your expertise related to the appraisal value for property in Fairfield.
Ask this witness the questions.
That is correct. So I am overruling him, but you have to go back to the things that you made part of the record on your own statement and have the witness answer whether he knows that information or not.
The statement that I just made on the record?
Correct.
Okay. Are you aware, Mr. Kronk, of a district court case that determined that the 1.5 premium that I was mentioning was incorrect and the premium should be some different number?
I was not aware of the premium. I don't find it particularly relevant. The Vastu homes are compared to other Vastu homes. I don't think this is going to change that.
The comparison in the case had to do with Vastu homes being compared to non-Vastu homes, and the Vastu homes being given a premium. You understand that?
I understand, but
Okay.
I'm saying that if you appraise a Vastu home, you're going to compare it to other Vastu homes that are going to have similar characteristics. If those Vastu homes both either have the AMI technology or don't, it's not going to have an impact on the value of those homes.
Okay, well, that's really the question. How would you know that? You've never talked to a buyer or seller of a Vastu home.
Well, what I've explained in my testimony is that if the options are to either have the meter or to not have the meter, the value is going to be the same.
Okay, well, that's speculation without having talked to a buyer or seller of a Vastu home. Wouldn't you agree to that?
I don't think you're understanding what I'm saying. So let me try and clarify. I'm saying if the AMI meters are allowed, and so every Vastu home has an AMI meter, that comparing this Vastu home to that Vastu home is not going to be any, there's not going to be any difference. And so there's no indication that the value would be different.
Except that the value of both of the Vastu homes, one with a meter, both of them having a meter, may decline because the purchasers aren't tied to Fairfield, for example, correct?
I think that's highly unlikely.
Well, what do you base that on?
Well, people have been coming to Fairfield for many, many years, long before there was a prevalence of Vastu homes available. So I don't think that it's an absolute that folks affiliated with the university or with the what I believe one of the other experts referred to as meditators absolutely require Vastu homes.
But you understand that people have been coming to Fairfield for many years and buying Vastu homes when there haven't been smart meters.
Yes, they've been buying non-Vastu homes and Vastu homes for many years.
Okay, but the Vastu homes that they've been buying that have not had smart meters. And now if they come to Fairfield and they want a home, if this AMA project is approved and everybody has to have a smart meter, then they will either have to buy a Vastu home with a smart meter or walk away, correct?
Or buy another home without with a smart meter.
Yeah, yeah. And may decide not to move to Fairfield if they want a Vastu home. I mean, you understand that there are Vastu homes in places other than Fairfield, correct?
Of course.
Okay. The other issue is you've seen the supplemental testimony of Mr. Lippman, about Access Energy's smart meter, correct?
I've read that, yes.
Okay. So they might decide, even if Alliant decides that everybody has to have a smart meter, that those homes in the Alliant area are less desirable than the Access Energy area, because the Access Energy uses a smart meter without wireless technology, according to the Lippman testimony, correct?
It's a possibility. I don't know where the Access Energy area is.
Well, the Access Energy area is partly in the Vedic City area and partly not in the Vedic City area, but there are many, I think it's in the record, there are many Vastu homes in the Access Energy area. So a buyer could decide, because Alliant has smart meters with wireless and Access Energy doesn't, that the buyer will go to the Access Energy area rather than the Alliant area, correct?
They could decide that for any number of reasons.
They could. But you don't know from talking to the real estate brokers, again, what their principal reasons are for walking away from a home, correct?
That is correct. In Fairfield,
Okay.
I do not know that.
So you have a statement on page 7 of 14 of your testimony. And I'm sorry, that testimony is the market overall rather than the market for Vastu homes. Correct?
That's a general,
Okay.
yeah, not Fairfield specific. That's
But-
just a general.
But in the Vastu homes, in the market, you say you don't believe a buyer or a seller of smartphone technology, that's going to be reflected in the market value generally of homes in Iowa or elsewhere.
I'm sorry, could you repeat that?
Yeah, it says, I believe the market overall would not recognize a significant difference in a dwelling with metering technology and one without. Line 21, page 7.
That's correct. I
Okay.
believe the market would recognize a difference in value.
Okay. But in the Vastu area, in the Fairfield Vedic City area, you really don't know that that's the case because of Alliant offering a smart meter and Access offering a smart meter without wireless, correct?
Objection,
Well-
asked and answered.
Please restate the question, Mr. Marcus.
Okay. You don't know that a person in the Alliant area, in the Fairfield Vedic City area, with a Vastu home, whether that person is going to have his market value diminished compared to the person with a home in an access area in Fairfield or Vedic City. You don't know whether there's going to be a difference in market value.
Well, there's no data, so nobody knows.
Yeah.
In my professional opinion, there would not be a difference.
Okay. Do you know of situations where people in Fairfield who are looking to buy a Vastu home have walked away from a purchase because they're concerned that smart meters are coming?
Not specifically, no.
No. So you don't know if that has happened or not.
I do not.
You say on page 9, line 14, that with respect to Miss Town, she gives no evidence to support her claims regarding the effect of AMI meters on the value of homes in Fairfield. You remember that testimony?
Yeah, I didn't see any evidence in her testimony.
But that is because you don't believe her personal testimony, her personal experience is evidence, correct?
I don't believe she indicated any specific reference to value in her testimony.
Well, not to value, but that buyers consider it very important, then they want to walk through the homes and whatever. You saw her say that. Maybe you don't consider that value, but
I don't disagree with that testimony that she
Okay.
said that. She did not give any evidence to indicate that had an impact on value.
okay. If you see a home that's on the market for a long time, you do see that as an indication that there may be a problem value-wise, correct?
Could be any number of problems.
But that's
Could be that it's overpriced.
But that's one factor, at least, that you consider, how long the home has been on the market, correct?
Consider when doing what? I'm not sure what you're asking.
Consider when making a determination of the value of that home.
If a home has sold,
No, it's been on the market for a long time, and it hasn't sold. Is that an indication that there's something wrong with the value of that home? There's something the market doesn't like about that home?
it's not necessarily an indication of that they don't like the home. It's possibly an indication of that, or it's possibly an indication that the sale price is too high, or it could be the location isn't right. It could be any number of things. I'm not sure what you're asking.
Yeah, I was just asking if that's one factor that indicates there may be a problem with the marketing of that home. Isn't that obvious? That
With the marketing of the home?
Well, the marketability, let's say, of that home.
It's possibly that's why it's been on the market. There could be any number of reasons that have nothing to do with the home.
Okay. Yeah. I have no further questions.
Mr. Turner?
Yeah, maybe two questions. I just want to try to understand. There are two things. One, are there other people who can evaluate the value of a house besides someone in your profession?
Depends on for what purpose. I mean, anyone can put a value on a house. It's whether or not they're credible in doing it.
And so, are there other people in sets of people that are credible in putting a value on a house, like perhaps a buyer and a seller?
Well, typically buyers and sellers aren't particularly credible in terms of valuing their own property, in my opinion.
So
they have bias.
So what do you base your value? What do you base your analysis on then? Isn't it on what the buyer and seller agree upon?
Comparable sales, yes.
Yeah. I have more questions than I thought, given your answer. Isn't the fundamental principle of the value of the house what the buyer and the seller agree on?
Well, what a buyer and a seller agree on for one house, I would not say is necessarily indication of the value of that house. We see a lot of times when buyers and sellers will agree to prices that are below or above what that house is worth. The last house I bought appraised for $17,000 more than our agreed upon sale price. But that particular seller was eager to sell the house because they'd already found another property they wanted to buy. So
Does that indicate that there are subjective factors in figuring out the value of any particular sale?
certainly, and that's why we like to interview buyers and sellers and make sure we know
And
what
so
the
is it
story
possible that people who look for real estate for specific health reasons might put a subjective value on the presence of a radiating meter in that house and see it as less valuable as a result of that?
Yes, it's possible that an individual would do that, but that does not mean the market value of that property has changed.
Does it make it harder for the seller to sell if there are people who believe that?
I can't answer that question. If that's what everybody thinks, then yes. If that's what a small segment of the buying population thinks, then maybe not.
But even the small segment reduces the value of the house by the amount of the small segment, isn't that correct?
I'm sorry, ask me that again?
He said even a small segment of people who say, I am not going to buy this house because my health beliefs and my idea about architecture tell me that this house is not as valuable with a meter as it would be without a meter. Even if a small number of people believe that, doesn't that lower the value of the house, at least by the amount of that small number of people?
I don't believe so, no.
And why, explain to me why you don't believe that.
Well, if let's say there's a pool of 100 potential buyers of a property, and we're talking about one property, and 3 of those people would not buy that property because of any particular characteristic, health or otherwise, there's still adequate number of potential buyers for the value of that property to be realized.
Well, didn't you indicate that there was a set of people who like to buy these kinds of houses, and they have a set of beliefs about houses, and they are interested in buying houses that advance their health?
I don't believe I testified.
Didn't you
to
say
that.
meditators?
I believe I said meditators have, it's my understanding that someone else testified that meditators are interested in this, yes.
So if there were meditators, let's just say meditators, whatever that might mean, who valued houses that did not have radiating devices in them as the market for the houses, would putting a radiating device in that house lower its value?
Well, I don't believe it would, but I would indicate, I believe it was Ms. Town's testimony that many of the meditators seek out these houses, not all of them, and certainly many meditators live in houses that are not Vastu homes. So I just think there's an adequate pool of people that you would not have the issue that you're suggesting.
Well, the question is an adequate pool. The question is, does putting the meter in reduce the pool?
It may reduce the pool, but that does not mean it reduces the value. That's what I'm indicating.
Well, if the pool is reduced, doesn't that reduce the value intrinsically? Isn't that the whole point?
Asked and answered.
I believe it's a different question.
I'll allow him to answer it.
I think I already answered that. If there's still an adequate pool, then the value still can be recognized.
Anything else? No further questions.
Member Wagner.
Thank you, Mr. Cronk. I just have one question. If a property has a monthly charge, does that change the value of that property?
I believe if that's in my opinion, if that's a voluntary charge, it would not change the value of that property.
Okay,
In other words, if they're choosing to accept that value, that charge, then no, it would not impact the value.
Okay, thank you.
Board Member Lozier.
Thank you. You state in your testimony that you've performed approximately 1,000 appraisals.
Yes, sir.
And how many of those were residential appraisals?
Probably less than 5%. Well, in terms of single-family homes,
Yes.
probably less than 5%.
So 50.
Probably.
And how many of those 50 appraisals of residential, single-family residential properties had smart meters in them?
Probably none.
You state in your testimony that there is evidence that shows there are vast few homes with smart meters. What's the source of that evidence?
Well, there was some previous testimony that indicated that. I believe
From whom?
now. I don't recall whose testimony that was. Not today, but written testimony that I was provided. Somebody, I believe, with IPL.
And you conclude your testimony saying the installation of AMI technology may not be preferred by a segment of the market, but this is a relatively small characteristic that is not likely to deter a potential buyer or impact market value. You recall that testimony?
That's my opinion, yes.
Have you read any of the 600 or so complaints that have been filed in this case?
I have not.
Thank you.
Can we go back to Board Member Lozier's question for you on page 9 of 14 of your testimony, lines 10, 11, and 12? I'm also interested in the data provided by IPL indicates. what data, and if you don't know, I would like to know what data was provided that included the information on the Vastu homes and where that's at in our testimony. Do you know, Mr. Kronk?
I don't recall whose
Okay.
testimony it was, but I believe Mr. Callisto can probably point that out.
Your Honor, it was testimony of Randy Bauer, I believe, in rebuttal. I'm finding it right now. We provided that testimony to Mr.
You
Kronk.
can just, because I'll keep going and then we'll wait on that. Have you ever heard of NIMBY?
Yes,
Do you know what that stands for?
yes,
What is it?
not in my backyard.
Do you believe that there are instances where property is valued differently because of what is in a person's backyard?
Sure.
Do you believe that there is real estate that may have stigmas attached to it where the property would be valued less, such as next to a polluted lake?
I think that's probably true, yes.
What about gated communities? Higher or lower value?
Are gated communities, do they have higher or lower values?
Yes.
In general, I mean, there aren't a lot of gated communities in markets I've worked, but probably in general they're higher.
If you can, provide me with that.
Your Honor, it's in the rebuttal testimony of Randy Bauer, beginning on page 12, line 21, and continuing through essentially page 14, the bottom.
Mr. Callisto,
Yes.
do we have data request number 1.11?
I'm sure we can get it. For Mr. Littman or Ms. Matera?
Excuse me?
Do you know if it was issued to Mr. Lippman or Ms. Matera?
Mr. Lippman.
May I approach, Your Honor? I'm sorry, that's the wrong one. My apologies.
Mr. Callisto,
Yes.
do you have any further?
I'm sorry, no
report?
redirect.
Seeing nothing further, the witness may step down. Mr. Callisto, do we need to set up the webinar?
1 second, Your Honor.
Yes.
No, we will waive cross on,
Mr. Schuling,
I have no cross.
Are we
we're
talking
talking
about,
about Miss Town. We will waive cross on Miss Town.
so,
Mike, please.
yeah, first of all, I'm not sure of the procedure here, but if we don't want to accept the waiver, can we refuse that and have Ms. Town talk or not?
Well, you can, but here's what would happen. We would put her up on the stand. We would have you, we'd call her on the stand, right? And you would introduce her, we'd present her. There would be no questions from any of the parties.
That would be it.
Right.
Okay.
So I guess the question is, Mr. Turner, are you going to ask her any questions?
Just let me check. No.
But there is a stipulation, correct, for a change in testimonies?
The one correct.
Yeah. And then I can tell what that is if I can get, can you give me Town's testimony?
Say what?
Town's
Do you
testimony.
have Town's testimony? Is it in here?
It's not right up here.
Oh, right here.
Let's find some more.
She's getting it.
Okay. Do you happen to have Town's testimony?
Mr. Kronk, I know you're relaxing. We are calling you back on the stand. So by the time the board gets done answering these questions, will you two have figured out what you want to do?
Yes, there's just,
Mr. Kronk, you realize that you are still sworn in?
Yes.
Ms. Board Member Wagner, you may proceed.
Kronk, I apologize for bringing you back up here, but
No problem.
one further question did come to mind. If there are two properties,
okay, yeah, I've got it.
both vast two homes, one has an option to opt out of an AMI meter, and the other home does not have that option and is required to have an AMI meter, which home do you perceive would have the higher value?
I don't believe there would be a difference. I don't think the market would recognize a difference in value as a result of the AMI technology.
Even if there was one that was required to have it and one had an opt-out and didn't have to have it?
That is my testimony. That's my opinion.
Okay, thank you.
You may step down. Mr. Marcus?
Yes. Mr. Turner is not going to cross-examine, but we do have one correction to Ms. Town's testimony. That is a stipulation that can be changed, even though they're not calling the witness.
Would you, so that I have a better idea of what I'm agreeing to, tell me what that
Yeah.
change is?
Yes. On page 2 of her testimony, in lines 13 to 16, she states that on average, over a 12-month period, I would say that I discuss with or represent as a sales agent 7 or 8 buyers or sellers of these homes. Of course, there are more prospective buyers in the summer and less than in the winter. The change is that on average, over a 12-month period, I discuss with or represent as a sales agent 7 or 8 buyers or sellers per month of these homes. So it's not an annual number of 7 or 8, it's 7 or 8 per month.
I'm just going to repeat, then the only thing that's being added is we're adding per month into the testimony.
Correct. 7 or 8.
Sellers per month of these homes.
Right, correct.
Okay. Is there any other additions or corrections to the testimony?
No.
Is there any objection from any of the parties?
No objection from OCA.
Mr. Callisto?
No objection.
Mr. Turner?
No objection.
Hearing no objection, the testimony as amended is admitted. Mr. Margus, are you going to let her know, or is somebody going to let her know? Okay, thank you. The board needs a 15-minute break. We will come back at about 4:25. Dr. Shi needs to be mic'd. Thank you. Is there any other issues that need to come before the board? We will be back here about 2:15, 2:20. We are adjourned.